I'm very excited about this panel because charter values has been this stealthy concept that has been spreading its tentacles into much of the charter jurisprudence. I have my own views about charter values, but they're sort of segregated into the Section 2B part of the section of the charter values story. So that's not really so much what our panelists are going to speak about this afternoon, but we're in for a treat because we have three very fine panelists and three very well-developed papers that take on this difficult subject of charter values and try to help us understand what they are, where they appear, and what kind of a critique, what kind of a future we see for them. So our first speaker is going to be Dean Lawrence Dawson, who, as I said earlier, needs no introduction. Beyond being our estimable leader, I will simply introduce Lorne as a leading figure in administrative law scholarship in Canada, and his main connection to the charter values story is through administrative justice. Now, Lorne, I have to ask you, is your co-author here? Okay, so Lorne's co-author is Mark Fridman, yes? And he's here with us today, so I just want to acknowledge you and as part of the team that wrote the paper. Our second speaker will be Chris Bratt, who is senior litigator at BLG and does a lot of public law litigation and is a frequent speaker at constitutional conferences, including this one. Has also written a paper, also has a co-author, Eva Krajewska, who is at the back there and with us today. So welcome, Eva. And the third speaker will be Matt Horner, who's with the Constitutional Law Branch. And Matt's new as a speaker to the conference, I think, this year. And he's been at the Constitutional Law Branch since, I'm guessing, 2006. That's what I remembered. And it's one of the greatest jobs in the city. He has the opportunity to be engaged in a lot of constitutional adjudication. He's also written a very interesting paper on charter values. My introduction has been too long. I'm going to have to enforce time limits on the speakers. So, Lorne, the clock is ticking.
Go for it. Thanks, Jamie, and thanks also for acknowledging Mark Friedman. And as is usually the case with these co-authorships, if you sense something of a bold new day and important new ideas, that's his work. If you sense a certain tiredness, I've read this before, hasn't this just been recycled from 4 other articles? That's all me. But I think this is a topic that is really about a bold new day. And like bold new days of old in public law, certainly in administrative law and the charter, it gives rise to uncertainty, to risks, to real worries, and you're going to hear about some of those from Matt and Chris as well. But I want to make sure to focus on some of the more hopeful notes. And this case is really a point of departure, I think, for answering a question I've been wondering about for a long time. I see John Evans sitting up there. I think I've been wondering about it since I was an administrative law student in his class, which is what would the Charter of Rights have looked like if it was developed by and for administrative justice rather than by and for courts? And I think the attempts to simply graft a structure, a way of thinking, and a way of resolving disputes that was developed by and for courts simply onto tribunals or onto administrative justice settings has not gone well, is not well conceived, and won't lead us to good places. And I see Dore and Charter Values really as a first serious engagement with wondering about what would it take us to if we took administrative justice seriously and the expertise of those who live in those very contextually driven settings. So that's kind of the premise. The outline, again, of the paper is up there, and anything I don't get to, I'm happy to address or ask Mark to address if it's a hard question in the Q&A to follow. And again, the paper is available and, of course, goes into more detail in all these areas. So I'm going to assume, again, most of you have been to these conferences, followed the development of this jurisprudence, which is about the engagement of the Charter and administrative law. It's had 2 general strands. One strand is about what to do when there seems to be an interpretation of a statute that could be dealt with in administrative law terms, but it also engages charter rights. Do you apply one or the other, one then the other? What goes on when you try to resolve especially area of the exercise of administrative discretion under the charter, in which case there's often a challenge around the Oakes analysis and proportionality, or under administrative law grounds where there's traditional anxieties about what standard of review to apply, what reasonableness means, so on and so forth. And it's gone back and forth, and there's actually some good acknowledgement in Dore, I think, that it really hasn't provided clear guidance to anyone, to lower courts, to decision makers, to parties, their counsel, and it really has been a bit of a dog's breakfast. The other line of cases in which the court doubled back from a pretty restrictive view of when tribunals and decision makers could actually hear and decide charter claims to a much more expansive jurisdiction, particularly in the Martin and Paul decisions that doubled back on the earlier view only in the mid-90s in Cooper, and Martin and Paul were in the early 2000s. So for at least 10 years, we've had some clarity that tribunals can hear and decide charter cases, but again, very little attention to how would they do that, with what capacity and resources in worlds in which, again, the norm is not legally trained decision makers hearing arguments from lawyers on both sides, and it's quite typical, and in fact, the norm in the majority of tribunals that hear the majority of disputes to have a non-legally trained decision maker resolving a dispute between two non-legally trained parties or parties without counsel, where there's about an hour to 2.5 hours of time allotted to do so. So that's the world I'm looking at. And simply to say, if you've got a serious jurisdiction to apply and resolve general questions of law and apply legal principles to them, you can have jurisdiction to hear and apply the charter, really just makes no practical sense, even though it has a certain logic in the development of this jurisprudence. And what, instead of how this would actually work on the ground, we get the Chief Justice's soaring rhetoric in her oft-quoted lines from Cooper and other cases that have used this about the charter not being the holy grail, not being just for the initiates to touch, but there where all the disputes are resolved. And I think there's no question now on the part of anyone in recognizing the overwhelming majority of disputes that involve law and engage people's lives happens in administrative justice. The courts are an apex that really takes a sliver of disputes, applies a sliver of legal principle, and yet under the charter it's the exact reverse pyramid, where courts loom largest and tribunals have been an afterthought. And there's nothing intuitive about the charter or its rights that would suggest this. In other words, they're meant to live in actual context of disputes, not in a rarefied or abstract graduate school discussion. So it's curious that it's at the level of appellate courts, the farthest from the lived reality in administrative justice, that we've had the development of these principles. And that's what I think Dore, again, is trying to react to or against, or at least put into some new perspective. The case, in a sense, could have been any case, and the court says this could have been any case. There's nothing about Dore that would have required the application of charter principles or charter values in any way that's special vis-a-vis many, many other cases that have been heard. But they just decided, the court, to take this case on as one to explore this notion. It involved the dispute between a judge and a lawyer about who was the worst and most despicable person in the history of humanity. The lawyer thought it was the judge thought it was the lawyer. Everyone complained about everyone, and it worked its way both through the Canadian Judicial Council and the Barreau, and it's the Barreau's decision in particular to impose a reprimand as part of their remedial discretion that ultimately works its way up to the Supreme Court on that application of the discretionary power to remedy violations of professional conduct. And what the court says is that we could, simply look at this from, this standpoint of the existing jurisprudence, or we could look at administrative law in a different way. And this is Justice Abella's notion, although it builds on the earlier view of some of the judges in Multani, that there's a richer conception of administrative law in which the exercise of discretion itself is meant to be infused by charter values. And under this approach, it's not the charter framework, it's not a case made by the claimant under a specific right to then be countered by the government under Section 1 with notices of constitutional question and formal charter jurisdiction and all the bells and whistles. Rather, it's that administrative discretion has always been, in a sense, framed by a certain set of implied obligations, one of which is to be consistent with the Charter's values. This, of course, begs the question, well, how would you do that? And the court has a very simple methodology in mind, but it's simple yet distinct from other charter methodologies dealing with the judicial role. In this case, a decision maker is to balance charter values against statutory objectives. This is particularly relevant because we learn in the Supreme Court's jurisprudence, like Ocean Port, that every administrative justice context is distinct by definition from every judicial context for exactly this reason. There is a statutory framework with a policy purpose underlying it. That's what makes administrative justice, and that's what makes it not what goes on in the courts. So this idea of balancing the reason for your existence, administrative decision maker, with your understanding of charter values, and then finding a solution that will best protect the charter value and best advance the statutory purpose. That is something that administrative justice decision makers arguably are distinctly well suited to undertake, depending on what we mean by charter values. And what do we mean by charter values? Or more importantly, what did the court mean by charter values in this decision? Well, I want to suggest there are two possibilities. One is they used charter value but didn't mean charter value. They meant just the same old charter rights with the same old words and the same old document that we've been using in courts all along. And they just used this word because they weren't sure administrative justice makers could understand the word rights, and so values was put in there, but it's meant to be the same exact thing. And that would be puzzling, because if you're going to choose another word, why choose a word that actually has a different definition in the court's jurisprudence? Charter values don't, in fact, line up in a way that is entirely the same as the wording of charter rights or the balancing exercise, for example, built into Section 7, or the way in which we understand the work of Section 2B to be done in Section 1. I mean, none of that is necessarily captured by using the term charter value, and I think most people on the plain reading of it would say something else must be going on. The other way to read it is that it's in fact meant to be something different, meant to be a broader sense of principle in which it's animated by charter provisions, but not in any way restricted or limited to them, or at least to the understanding of them that courts have developed so far. So that takes us to what has been recognized, at least in the judicial context, around charter values. In our paper, we don't purport to do an exhaustive review, but we identify at least this list that I'm putting up on the slide now. These, in other words, are all areas that have been equated as to or described as charter values so far in the court's jurisprudence. And again, it remains to be seen what will be developed or expanded upon in various tribunals or decision makers' views as Doré is applied. If this view, in fact, prevails, that charter values are meant actually to be something different than the mere words of the Charter of Rights. So, for example, human dignity appears, as we know, in no provision but the preamble. Privacy appears in no provision, and yet each has been recognized time and time again as a charter value for different purposes. Autonomy, fairness, expressive freedom, again, beg the question, is expressive freedom a value? And if it's a value, is it simply the totality of what the court has said about Section 2 rights, or is there something else or broader there? Well, again, if you look at Doré itself, I think the argument for a different and distinct jurisprudence or body of understanding and perspective on the Charter from administrative justice would say the way in which you regulate a lawyer's speech in the context of professional discipline in the work of an elected body of decision makers that run convocation or the barreau is entirely different than other settings of expressive freedom. It's entirely distinct to the policy goals, to the expertise, to the day in, day out lived experience of that body and its context. And we should expect different and importantly different insights about expressive freedom to develop there that may or may not have any application across in immigration or in dealing with extradition or how prisons are managed or universities and so forth. And I want to suggest that there is an analogy to the development of charter values in something much more familiar to tribunals, which is the development of notions of fairness. But first, of course, it's worth asking what have tribunals done with Doré, with charter values, and it's fair to say not much yet. There is an initial grappling with what does this mean procedurally. Do we have a charter analysis and then a separate charter values analysis? Is this simply part of our discretion? We've had the charter values invoked when no charter claim is at issue, and sometimes it's an afterthought. In the University of Calgary case, it was essentially decided under the charter, and then the decision was, and if this isn't right, well, then I would have done the same thing under charter values, and people just aren't sure what to do first or separately. But coming back to my first point, the reason I think charter values has this bold new day potential is because you don't have the formal presentation of evidence and citation of charter jurisprudence. It's not by and for lawyers that I would argue we're going to see the development of charter values, which is why the Law Society may be a bad example to have developed it in. It's going to be in the worlds of these bodies, landlord-tenant tribunals, social benefit tribunals, health profession boards, boards that deal with labor, boards that deal with that wonderfully diverse and disparate universe of administrative justice. Even worlds where the charter itself has been removed from those bodies by statute, because you can't remove charter values. Wherever there is any statutory discretion, the charter values must by definition follow. So in that sense, we're not giving issues of notice of constitutional question and presentation of evidence. We're looking at a world in which this can be developed, and I would suggest ought to be developed from the ground up, and it will mean different things in all those bodies. But as I suggested earlier, we had the same world in the late 1970s around fairness. Fairness, when it was expanded from judicial and quasi-judicial bodies to all bodies that had ultimately the test of a non-legislative public decision engaging rights, interests, and privileges, people say, well, what does that mean? That's indeterminate. It could mean something different in a prison, something different in a labor board. That's chaos. It turned out not to be chaos, but the development of an incredibly vibrant, contextual, variable body of understanding that has very much been from the ground up. And it doesn't look like a court, and it doesn't look the same across jurisdictions or bodies, but the sky hasn't fallen. And over time, we've worked out actually a pretty clear and shared understanding of where fairness is applied and with what kind of variability, as of course the synthesizing analysis in Baker brought into sharp relief. And the other key to Doré, and I'll finish with these last couple of points, is that not only is it for the tribunals and decision makers to develop this understanding of charter values, the scope of them, the application of them as against statutory objectives, but also, and remarkably in a sense, the court calls on judges in Doré to defer to those determinations. In other words, when it comes to understanding the charter values in that context, judges will not be the smartest people in that room. The decision makers will be the smartest person in that room, and at least within the scope of reasonableness should be able to develop space to have their own articulation of these values. And this, again, as I suggested, overcomes some of the formalism, some of the problem that we had in the past. Fairness, as I said, is a template or a model. And then I finished with a sense of what are the unsettled issues going forward? You're going to hear more, I think, from both Chris and Matt about what remains unsettled, and problematically so. And I don't think I disagree with the concerns or risks in this kind of fuzzy time period we're in the post-Doré era. But I want to suggest what I'm most interested in are things like how we adapt charter values to that diversity of settings. And again, not relying simply on parties represented by council. What role will active adjudicators who have an internal mandate to ensure statutory objectives are met with charter values in mind, what will they do, and how will that happen in a transparent and clear way? And I skipped over a slide in which we map out a bit of a methodology to try to bring a fairness-like way of thinking about charter values so that there is at least that ability to build on a shared template of approaches, even if each body will infuse it with a different content and perspective on charter values. So that's a bit of why we think Bold New Day. Hopefully that's provoked a thought or two in your own mind, and certainly I know from reading Chris and Matt's work, it's about to come under the important glare of some considerate scrutiny, and look forward to the discussion and to each of their analyses to come. Thank you very much.
Thank you, Lauren. The next paper is by Chris Brett and Eva Krajewska, and we get a bit of an idea with the style of the titles for the next two papers. The next paper is called Doré and Charter Values, All That Glitters Is Not Gold.
So first of all, I do want to thank my co-author, Eva Krajewska. She's always taken on mission impossible around the firm, which is to work with me and to try and make me look good. And so to the extent that she succeeded in this paper, I thank her. I'm going to scoot. I've got 3 points that I was going to deal with. First of all, just a quick review of Conway and what it said about jurisdiction of administrative tribunals. Look quickly at Doré, and I hope to spend most of the time on a critique of Doré. And while I agree with Lauren that there are some good parts to Doré, you'll see that I'm not the fan that Lauren is. So if we look at Conway, what did Conway do? Basically, Conway said that administrative tribunals are going to have jurisdiction to consider the charter in circumstances where they have the ability to interpret the law, which is in most cases, and also they have to have jurisdiction over the remedy, and so it cleaned up the previous case law, which made a distinction between Section 52 jurisdiction and Section 24 jurisdiction. And in Conway itself, which was written by Justice Abella, there was what I call a charter values teaser in there. So she brought together the Section 52 and the 24 jurisprudence. But at the end of the decision, she talked about how charter rights can be effectively vindicated through the exercise of statutory powers and processes. And it says, in this case, it may well be that the substance of Mr. Conway's complaint about where his room is located can be fully addressed within the framework of the board's statutory mandate and the exercise of its discretion in accordance with charter values. We didn't really know what that meant. So Doré really was what told us. And as Lauren said, Doré's, what a great case. I mean, we've all been in court, and we come out of court, and we're just mumbling under our breath about what an asshole the judge is and so forth. And usually what we do is we go and have a beer, and we go home, and we sleep it off. Doré was not that person. I mean, you love the letter he wrote. You've heard it all before, but I like to read it. I'm going to, it's great. It says, if no one's ever told you the following, it's high time someone did. Your chronic inability to master social skills, to use an expression in English, that language you love so much, which caused you to become pedantic, aggressive, and petty in your daily life, makes no difference to me. After all, it seems to suit you well. I could go on. It's what we all think. After we've had the crap beat out of us, but usually we don't have the gumption to write it. So, as Lauren said, both the judge complained about the lawyer complained about the judge. It comes before the barreau, and he gets disciplined. He raises freedom of expression. And one would have thought, coming up to the case, I mean, the borough, it's a government authorized by statute. It exercises, and someone's raising a charter issue. It's, you know, you can deal with it in the good old-fashioned charter way. But that's not what the courts did. Now, before I come to talk about what Doré actually decided, I think it's important to understand the different ways in which charter issues come before administrative tribunals. So if a statute or regulation is clear, then before an administrative tribunal, you can challenge it on the grounds that it's contrary to the charter and can't be applied. And while administrative tribunals can't give declarations, they can decline to apply the provision before them. So there's a statute, even the statute that creates the body, you can challenge it. They can say it's contrary to the charter, we're not going to apply it. The second area that administrative tribunals can look at is where a statute or regulation is unclear. That is, it could be ambiguous. And in that case, you could say, look, you got to interpret it this way, because if you don't interpret it this way, it would create a constitutional issue. So you use the charter to say to the court, you resolve the ambiguity in a way that would make it constitutional. And the third way that charter issues come before administrative tribunals is the Doré case, where the statute or regulation is not ambiguous, it's clear, it grants a discretion, and essentially the argument is that the exercise of the discretion would be contrary to the charter, and that's the case that was in Doré. They're saying, clearly it's constitutional to reprimand lawyers for conduct unbecoming, but the argument was you're exercising your discretion in a way that violates my charter right to freedom of expression. So what did Doré decide? First of all, they had to determine whether administrative decision makers exercising their discretion in accordance with the charter, the question was for them, are we going to apply an administrative law approach or a charter approach? And I won't get into the background. In Slate, Chief Justice Lemaire said, you do an Oakes analysis. You come to Baker, and Baker seems to suggest, no, you kind of weigh the different factors. It's more of an administrative law approach. In Multaney, a majority of the court said, no, you do an Oakes approach. Abella, in dissent, says, no, you do an administrative law, and you come to Doré, and they say, it's the administrative law approach. You're not going to apply Oakes. And what do they say the administrative law approach is? It says, when applying charter values in the exercise of statutory discretion, an administrative decision maker must balance charter values with statutory objectives by asking how the charter value at question will be best protected in light of these objectives. This is at its core a proportionality exercise and requires a decision maker to balance the severity of the interference of the charter protection with the statutory objectives. And what I'm going to say to you is, she says it's not Oakes, but to me, there's a heck of a lot of Oakes into the proportionality test that she suggests in Doré. The other thing that they say is that the standard of review on the application of charter values is going to be reasonableness. So let me move then in the last part of the presentation to my critique. First of all, charter values versus charter rights. And as Dean Sawson said, there's really two streams of charter values. The first stream starts with cases like Oakes and health services. And what the court says is you've got to look at charter values, things like human dignity, as a way of giving meaning to the rights that are set out in the charter. So it's a broad concept, and it's not rooted in rights that are specifically set out and protected in the charter. The second stream is where courts have been using charter values to assist in the interpretation of the common law. Primarily in expressive freedom cases like Hill versus the Church of Scientology, Grant versus Torstar. And in that case, the court says, well, look, this is not a charter right. It's not a charter right because these are private litigants. We're interpreting the common law. And so they give it the term charter value. And it's a charter value because the charter doesn't directly apply to private litigation. So it's a narrower concept, and it's a concept that's rooted in rights that are specifically set out and protected in the charter. And I say that to the extent that we're going to get into charter values, they should be directly rooted in rights that are protected in the charter. And I say that for a couple reasons. First of all, the indeterminate scope of the broad charter values that Lauren talked about there, things like autonomy, human dignity. The problem with those is that they're broad and they're undefined. And one of the key aspects of administrative justice is you want to structure discretion in a way so that you don't have unbridled discretion. Concepts like human dignity, I mean, they sound great, but they're infinitely elastic. The second part there is the advantage of using charter rights is there's an established body of jurisprudence that the administrative tribunals can look to say and inform what the charter value would be. The second aspect of this is, quite frankly, I just think it's illegitimate for the court to say, well, human dignity is important and therefore we're going to start applying it. Human dignity didn't make it in. Neither did autonomy. We amended the Constitution, and certain things made it and others didn't, and I don't think it's appropriate for the court to be expanding that. Second point deals with the standard of review. The court says, is a reasonableness standard appropriate? And I say it makes no sense at all. First of all, consider the range of administrative decision makers. I mean, you have on the one hand things like the barreau, where you have a fully fleshed out court-like process. But you have custom agents. They're administrative decision makers. And, someone comes up and, are you declaring something? They make decisions there. And are we going to give them deference? Are we going to give people that aren't exercising court-like processes the kind of reasonableness deference that the court suggests? And think about the anomaly of it. You have a superior court judge who gets reviewed by a court of appeal on applying charter values. What's the standard of review? It's correctness. And you compare the expertise of an administrative decision maker to a superior court justice, you'd say, why are you giving reasonableness to the exercise of discretion by an administrator when a superior court justice gets no deference? The other aspect about this is that think about the anomaly, because the other two things I talked about at the outset, which is declaring things invalid or interpreting things, administrative decision makers are reviewed on correctness. So as soon as it becomes charter values, all of a sudden it's reasonableness. But that doesn't make any sense to me either. Think about a law society. Let's say the law society passes a rule of professional conduct that says lawyers can't advertise. That gets reviewed on a standard of correctness. Let's say instead of doing that, someone complains about someone advertising and we look at it as conduct unbecoming. And we say, okay, well, it's conduct unbecoming. All of a sudden now, because it's the exercise of discretion, it's the same right, we get a reasonableness review. So I think the court needs to think a little bit more carefully about the standard of review. The last aspect of the critique deals with the proportionality analysis. The first thing that I would say is that I don't think necessarily it makes sense to have a different proportionality review for charter values than you're going to have for the underlying right. I mean, one of the advantages of the underlying right is the courts have developed a process that would inform how it gets defined, and to me it makes no sense that you should change that process because you're looking at it as a charter value as opposed to a charter right. The second issue that arises with these charter values are issues like onus and evidentiary issues. So with charter rights, if you're going to challenge something on the basis of invalidity, you have to give notice to the Attorney General. The Attorney General gets to show up. We understand that if you prove that there's a breach, the onus is on the Attorney General to bring forward evidence to show that it's a reasonable violation. Well, Attorney Generals aren't really party to a lot of these processes. So how is that going to work out? And in terms of, again, it comes down to the idea of giving deference to some of these administrative decision makers with respect to constitutional issues, the expertise that's there before the tribunals to raise the issue, the quality of evidence, all of them say to me that we ought to be cautious in the application of Doré. So I think I will end my remarks at that point, and I'm sure people will have lots of questions. Thank you.
Great job. I didn't even need to hold up the signs. Our final speaker is Matt Horner, and his paper title is Charter Values, the Uncanny Valley of Canadian Constitutionalism. I think it's set up for you.
I can get it for you.
I wouldn't know how.
It's a full-service operation.
That's how they make it. That's why he runs the show around here.
Thanks. And first of all, I want to say that I've been coming to this conference for about 12 years, and I'm so excited that I was asked to speak. I feel like I've made it to the show. So it's really exciting for me. I'm a total constitutional law nerd, and so this is a pretty exciting moment for me. So as things have played out, the consensus among the panel members appears to be that I've set myself up as the chief denier of charter values. And so Lauren and Chris are hard acts to follow, and hopefully I'll be able to persuade you of my way. I agree with many of the comments that Chris made. This week began with a Quebec election that resigned the Charter of Values to the dustbin of history. And I hope by the time I'm done on Friday afternoon, perhaps charter values will also be resigned to the dustbin of history. But not charter rights. I have to emphasize, I like charter rights. It's the charter values that raises my concern. And the title of my paper is Charter Values, the Uncanny Valley of Canadian Constitutionalism. And the problem with a flashy, pretentious, high-concept title is that you have to spend precious time explaining it. But I will do that, and I even have some visual aids, which I was pretty proud about last night, but then I saw Sonia's slides this morning, and I have all this anxiety now that they're not moving like lasers. So anyway, the Uncanny Valley. The Uncanny Valley is a concept hypothesized by a robotics professor in the 1960s, Masahiro Mori. And the hypothesis is that when the features of a robot look and move almost, but not quite like a natural human being, it stirs a negative emotional response in human observers. And so when you chart the graph of human likeness to comfort levels, you get a deep valley at the point just before a healthy human person. So basically you start off with an industrial robot, it's just a machine. So it looks like that, and you have no emotional response to that, it's just a machine. And then you move up towards a humanoid, and it starts to have human features like C-3PO or Wall-E, or this little guy, and you think that's pretty cute, so it looks a little human, and so you get a higher comfort level emotional response. And then at the top right-hand corner, you have a healthy person, like me, or any person who looks like me, or just basically me. This sort of this type of thing. A healthy person like me, and you're laughing because he may look, you think he may look better than me. But really, if anyone wears a cowboy hat and a leather vest, they end up looking pretty good. So that's. I thought these two went too well together last night. I just kept flipping back and forth. So anyway, so that brings us then to the uncanny valley, and that's the point where it just looks almost human, but not quite. And you have these disturbing robots that look sort of half human and half not. And that's the uncanny valley, where just something's a little off and it makes people nervous. And the same things happened with CGI graphics. In 2004, there's a movie, Polar Express, came out, and it bombed at the box office because these people are really creepy. They look almost human, but not quite. In 2004, another cartoon movie took the humanoid approach and was highly successful because it doesn't look human. It's in that higher response area. So anyway, that's the long title discussion. And so what does this leave us for charter values? Well, for me, charter rights are like a healthy human person. They're like me or Matthew McConaughey. They're awesome, and they're up in the right-hand corner. And then lower down in the humanoid part, you have discussions of charter values that are just more like sorry. They're just sort of used in a ceremonial way to mean the charter is a good and a wonderful thing, and so that's fine. I have a nice response to that. But my problem is with charter values when they're used and applied in the same manner as properly enshrined charter rights. But they aren't charter rights. Then what are they? That's the question. Are they an unwritten part of a written constitution? Are they a shadow constitution? And this is where things get confusing, and this is the uncanny valley of Canadian constitutionalism. In my view, the language of charter values adds nothing to the value of our constitutional jurisprudence. It diminishes the value of actual charter rights, and it creates significant ambiguity and complexity where it need not exist. So that's the end of the picture, sorry. So when we approach charter values, there are three questions we need to answer to address them. Where do those charter values arise? What are charter values? Meaning, what is their substantive comment? And why do we need charter values? So the first question is, where do we see charter values? And Lauren and Chris have touched on this already. We see them in the interpretation of common law, like in Dolphin Delivery and Hill and Scientology. We see them interpreting ambiguous statutes, like in Bell Express View. And we see them in applying exercises of statutory discretion, like in Slate or the Doré case. We also see them, as Chris mentioned, in interpreting charter rights, the scope of actual charter rights, but I'm less concerned there because that's more sort of a purposive approach to interpreting the Constitution as opposed to applying an actual substantive right. So I'm not going to stick on that area for too long. The question then is, what are charter values? And so here's where the confusion really begins, because it's never quite clear what courts mean by charter values. And because this is the 2013 Constitutional Cases Conference, I thought I would focus on highlight a couple of 2013 cases. This year, there's the case of Kearney, in which the court was applying the law relating to the defense of provocation. And the court had previously held that the objective aspect of that test must be determined with respect to contemporary norms and charter values. And the question was whether the defense of provocation applied when one man killed another man who had threatened the first man's female cousin. And in rejecting the defense on this charter values standard, the minority of the court helpfully noted, and I say helpfully sarcastically because it's not helpful at all, they helpfully noted that charter values do not include aggressively proprietary atavistic attitudes. So if you're wondering what charter values are, they are not aggressively proprietary atavistic attitudes. We can cross that one off the list, not a charter value. You know, I joke, but only a little. In my paper, I suggest three possible meanings for charter values. First, and this was alluded to by Lauren, is this idea that perhaps charter values are just actually charter rights, but used in a specific, as a specific term of art to mean a charter analysis without a Section 1 analysis. And that's what we see in the common law cases. There's no Section 1 analysis. That's what we see in the statutory interpretation cases. There's no Section 1 analysis. And in fact, in Doré, when Justice Abella adopts the language of charter values, she points to, and then adopts a proportionality analysis that's not the Oakes test, she points to these common law and statutory interpretation cases. So you could just be meaning that. And in fact, in Doré, obviously, it's just freedom of expression. That was at issue. Maître Doré never said, my charter values have been infringed. He said, my charter rights have been infringed, my freedom of expression. And so that could be the meaning, and that meaning might be sort of mundane and fine. But the language of other cases suggests that, in fact, charter values are much broader. And I'm going to jump to the third one, and this is where Lauren gets his broader examples of charter values, such as fairness and human dignity. And in one case, I'll highlight in Salaturo from about 25 years ago, the court talks about charter values as the fundamental values that provide the foundation of the charter, including, in that case, an imprecise conception of respect for the freedom of all individuals. So just general freedomness as being a charter value. And I have to say that this approach I find troubling because it would seem to provide a limitless array of charter values, untethered from the language of the charter, and therefore without any internal limit. And Salaturo is a great example because at issue there was respect for the freedom of individuals is not tied to any actual freedoms. In fact, the actual freedoms in the Constitution are listed: freedom of expression, freedom of association. The framers did not say just freedom. And therefore, it's kind of meaningless. And Salaturo is a good example because that case at issue was the common law rule of spousal privilege. And the court relied on charter values to limit the law of spousal privilege. But, and it did so by saying the right of the individual to choose freely whether or not to testify. But as anyone who's ever cross-examined anyone or been a witness in a proceeding, being a witness is the least free thing you could ever be. You know, there's nothing less free than being summoned to court, being forced to answer questions, you know, not having a chance to say what you think, and yet somehow freedom is relied upon to support the court's decision in that case. And that's just a thread that you see throughout the charter values cases. When the court says charter values, it seems to be that they stop thinking about what they're saying and they just sort of say, freedom, isn't that nice? The third possible meaning of charter values is a middle ground in which the charter values are not anything. They're limited by the enumerated rights, but charter values just means that you can lose them more loosely, and I call this charter rights light. And so that's an approach that would look at Section 15 and say, well, Section 15 has all this law about substantive discrimination, but we're just going to say, you know, is there any distinction, and that's enough, you know? Or Section 7, you look at life, liberty, and security of the person, you say, well, those are important rights, and you sort of leave aside the fact that the rights, in fact, you know, must accord with the principles of fundamental justice is an important part of that right, but the charter values, you just sort of take half of the pie. And I think as an example of this type of approach was seen this year in the Supreme Court case of Conseil scolaire francophone de la Colombie-Britannique versus British Columbia, at least seen in the arguments made in the case and by the minority decision. And an issue in that case was whether a 1731 British Act requiring that non-English documents be translated into English for use in court had been received into British Columbia law. And one argument raised by the appellants was that the interpretation of the law, including the 1731 Act, had to accord with charter values, and in particular, the charter value of bilingualism derived from Section 16 of the Charter. And the minority of the court would have required the trial court to exercise its inherent jurisdiction in accordance with the charter values of bilingualism. Now, you'll get no greater fan of personal bilingualism and official bilingualism than me, but the charter value of bilingualism, as advanced in that case, although ultimately rejected by the majority, departs significantly from what the text actually recognizes, which is a very specific set of rights set out at Section 16 to 20, which enumerate the various types of services, including the right to use either official language in court proceedings, but limits the scope of those rights to the federal domain and to New Brunswick. Other provinces can choose to adopt bilingual policies, and they may even choose to have those rights enshrined. But in this case, they had not. And so it seems logically counterintuitive to me that where no charter right obligates a specific legislative or government action, and wherein the text, in fact, states that the right exists for some purpose or in some jurisdictions, but not in others, that somehow the values underlying those charter rights could be read to require the exact opposite conclusion. So that brings us to the last point of why charter values. Why do we need charter values? And for me, this is the real problem. What value is created by charter values? And it seems to me there's been no clear explanation by the court of why we need to have this language of charter values. And Lauren has done his best to come up with a rationale for charter values in the administrative decision-making regime. And I think it's a good attempt, given what they've written, but I simply cannot agree with them. And I think Justice LaBelle had a great quote from the bench in oral argument this year in the Alberta Information and Privacy Commissioner case, in which he said, you can use charter values to resolve ambiguity, but not to create them. And to my mind, charter values create ambiguity. They do not solve it. I say this for three reasons. And I'm thinking mostly here about in the administrative decision-making world of, and first they require decision makers and courts to decide First of all, if they get this case before them, they have to decide whether something is or is not a charter value. And they don't have the Charter of Rights to look at because it's a charter value, and who knows what a charter value is. So they have to create this from whole cloth with no reference point. And this adds a whole new layer of complexity to these decisions being made by administrative decision makers, which in many cases don't have the expertise, and we're concerned about simplifying things. Well, you don't simplify things by creating a whole new layer of question that they have to ask. Second, once someone has settled on a charter value, the world of charter values has no doctrinal benchmarks upon which to apply that value. How can you tell if someone has applied a charter values analysis correctly? It seems to me that you can't, unless and until the Supreme Court establishes an entire jurisprudence around various conceptions of charter values. And that just seems to me like a lot of work to do towards very little end. And third, because charter values are so broad and amorphous, it ends up turning every case into a charter values balancing case, which seems to undo the value, the benefit of using values, and makes cases considerably more complex for decision makers. Competing rights cases are the hardest and most complex cases to decide. And the Supreme Court has frequently told us that we should avoid, whenever possible, creating a conflict of rights. Well, when you have broad, amorphous charter values, once again, you're going to be having these conflicts all the time, and it makes every case very complex. So basically, I see very little benefit to introducing charter values and the language of charter values into the discussion. And I see balanced against that lack of practical value, I see that the language of charter values also imposes a cost on constitutional doctrines and should therefore be rejected. First, charter values undermine the important role that charter rights play in our society. And the Supreme Court in the Gombach case has stated that the overuse of charter values pushes out the calibrated evidentiary and justificatory requirements of a charter rights analysis. And I say that applies not just when you're challenging legislation, but also a charter rights approach should be taken to controlling the government acts or exercises of discretion. You can take a charter rights approach, as the court did in Slate, and say, well, did that exercise of discretion have the effect of breaching someone's rights? And then if it did, you can say, was that a reasonable, and you can use a proportionality analysis like Dore and say, was that a reasonable limit on their rights? And that's a disciplined way to apply the question. Not just to wave your hand and say, well, there's some charter values here, and so I'm going to go this way with my discretion. Second, charter values create an unprincipled distinction, and Chris touched on this, between, in a different way on the standard of review, but it creates a distinction between decisions made on the basis of a charter values claim and those grounded on charter rights. Whether a decision arises from an act of statutory discretion or an express statutory provision, the substantive outcome for the individual should be the same. But a charter's values decision, based on a broader conception of charter protections, would seem to demand a different result in many cases. And finally, the language of charter values creates inconsistency in decision-making. With no benchmarks in place regarding what is a charter value and how it is to be applied, decision-makers will be forced to rely on their subjective views, which necessarily results in inconsistent decision-making. Inconsistent decision-making is fundamentally unfair decision-making, and even though fairness is a charter value. So this is the problem with relying on charter values for the advancement of substantive goals. I'm going to leave that. I'm just going to conclude by saying that the language of charter values creates no value and in fact causes harm to the decision-making process. Instead, what I propose is a modest proposal, is that decision makers should apply the law consistent with legislative intent. They should then determine whether, consistent with charter doctrine, such an application of the law would result in the breach of someone's charter rights. And finally, if it would, they can modify their decision to limit that right in a reasonable manner. I say it's all right there in the Constitution, and we should not adopt a whole extra Constitution in order to achieve that goal. Thank you.
Wow, I'm not sure how many of us today would have equated charter values with robotics. And I'm certainly not going to go there, but I'm quite sure that there are some questions from members of the audience for any or all of our panelists. Yes, Hugo, go ahead.
Okay. Well, thank you for this very interesting panel. When I was listening to you, I was wondering, well, two things. First is, because the emphasis was on administrative law and not common law, my understanding was that the charter values was initially used to broaden the use of the charter, and a bit like dignity, which was initially used to broaden the protection for equality law, then slowly it might have turned around in other fields or in another section and was used to restrict actually the guarantees. So I can understand why we use charter values in order to apply it to common law because of the problem between section 32 and 52, something that would not happen in civil law because the charter would apply directly to the rules in the civil code, which they don't to the rules of common law. So that's something I'd like to get your impression from. And the second thing is, I would be so worried to have administrative decision makers have their decision reviewed only on reasonableness after what we've seen in Quebec in the last election with registration decisions based on voting rights. Mm-hmm. Right.
Okay, I don't know who wants.
I could start maybe, Hugo, because I think the, that first question on, was the notion of values there to broaden charter rights? And Chris and Matt both have mentioned that common law jurisprudence where charter values are used in a particular way. And we looked at that in our paper and really said there's something different going on in administrative justice because by definition it is entirely a public setting. And every single exercise of discretion that we're talking about is the exercise of a governmental power in that sense. In other words, a statute that has authorized a person to do something. And just as that earlier case law Chris mentioned puts a unwritten rider on every grant of statutory authority and says it actually only can authorize such action as is consistent with the charter, and that's what Chris was mentioning. If it's unclear and there's an interpretation that is or isn't consistent, you have to go with the one that is, because that's always what the legislature intended and could only have intended. Similarly, when you're looking at that ambiguity and how to exercise the discretion, I think what DORE stands for is the view that it is always incumbent on a decision maker to be alive to, mindful of those values in the exercise of that discretion for the same reason, which is an entirely different rationale than that extension. And there are kind of other responses to the concerns around consistency and indeterminateness, but I think it's generally of a different character in this context. And to your broader worry, and again, this is the anxiety-provoking part, right? It's saying that judges and lawyers have more to learn from purveyors of administrative justice than the reverse in the charter values context. It's that old Dyson-Housian view of respect, of not being the smartest kid in the room when it comes to this. If Chris is right, and these are just meant to be charter rights applied in a different setting, I'm completely with him. Why would we defer? Why would we want this kind of chaotic group of people who don't think like lawyers and judges applying what we take to be a coherent set of principles? It's turning that idea on its head and saying, no, in fact, it is that group that we want to hear from, learn from, and it is going to look entirely different and ought to look entirely different. Well, then you get a second order problem, which is the one you raised. Who's getting appointed to these roles? Who are the customs officers? Who's getting appointed to the License Appeal Tribunal and the Social Benefits Tribunal? And I think that's great, right, that we take that as seriously as our discussion earlier about judicial appointments, that we see those as actually the apex of the justice system, because for the overwhelming majority of people in this country, they are. That's the only justice they're ever going to see, is what that registration decision looks like, that customs decision looks like. Why would we just say that that's worth sweeping under the rug because it's not something that fits within this coherent discourse of what a charter right looks like? And I agree completely with both Matt and Chris that for what the court has developed, for that charter jurisprudence, I wouldn't trust anyone but lawyers and judges with it. And that's why I've always found puzzling this idea that any tribunal should be out there Conway-like applying. I mean, the review board actually has lawyers and judges, as it happens. Makes perfect sense in Conway. Take that to the landlord-tenant board, I'd be deeply worried. Take charter values there, and I think we're onto something entirely different, which through reasons and guidelines and the working out over time, just like with fairness, we'll end up with a vibrant, variable, interesting, important area of thinking.
Did you?
I'll just say, I think you probably got the sense from, I don't think charter value should mean anything other than applying the underlying charter right. That is, otherwise, I think the whole idea of administrative laws, you want to structure discretion. This idea of unbridled discretion, that you can show up in front of me and you get one decision, you show up in front of Lauren, you get a different decision. That's not justice. Justice, like discretion, needs to be structured, and it's more easily structured if you have the base, you know what freedom of expression is, there's a body of jurisprudence that you can draw upon. And one concession I might make to Lauren on the standard of review is the distinction between the interpretation of the right or the value and the application. And I might be more willing to say they got to get the interpretation of the right or value correctly, but we're going to cut them some slack as to how they apply that in their particular context. And that may be a way of squaring the circle a bit.
I just wanted to say on the Supreme Court has sort of recognized the potential problem of charter values in the statutory interpretation cases as compared to the common law cases, because the common law, the courts recognize that, well, judges are making it up anyway, so if they want to throw in some charter values, that's fine. When they use charter values to interpret a statute or to constrain the exercise of their discretion, they're in fact limiting a legislative intent, which has been, passed by the legislature, a duly elected legislature, and so that's where it becomes more problematic. And even the Supreme Court has recognized that when we move into this world, we have to keep it limited to areas of genuine ambiguity or actual exercises of discretion.
Okay, thanks. I think we have another question. Yeah?
Thank you very much for that excellent panel. My name is John Silver. I am a JD student here at Osgoode, and I have a question for the one on the panel that is not the dean. And my question is, starting from first principles, right? The charter was developed in the context of the courts. And so if you look at Section 7 in 1982, and you look at Section 7 now, no one could have anticipated that sort of development. And that development came through the courts. So what legitimacy does a charter right have in the administrative law context, where we are not in a court, we're not looking at whether the law is unjust and trying to justify it based on legislative intent proper, we're looking at it as it relates in the specific on-the-ground context. And so if we look at first principles of the fact that the charter rights themselves are subject to judicial interpretation, and they've been the development of years of jurisprudence, how can we import that jurisprudence legitimately into a completely disparate context and say that that right itself is legitimate in the admin context?
I don't have a problem with it. The courts have dealt with this in the question of the scope, who should have charter jurisdiction through the Martin and Conway cases, and they've decided that most administrative tribunals should have jurisdiction. Most of them are competent to do so. If they're not, perhaps government should appoint better people to be there. I just say that I think that they can apply them, but they have to apply them to the facts of their case as rights, and not come up with a whole new system of charter values.
I think my question might have been lost a little bit in interpretation. And my question is not necessarily about whether or not administrative decision makers are legitimate in applying the rights. My question is, are the rights legitimate themselves as a definition of what Section 7 means, because they've been developed not in the, and it's touching on what the Dean has been talking about in terms of the on-the-ground decision makers and how administrative law looks different to them, and the charter might look different to them in their own context. So the question is, how is a right that's been developed by a judge in the context of a court, when looking at how it relates to a statute and whether that statute interferes with the right, how is that a legitimate right to then be used in a completely disparate context? Is there no way to reimagine the right in the administrative law context to have a different meaning? And may the courts be using charter values as a way to try and allow administrative decision makers to reimagine those rights on the ground, so that while we have one definition in the courts, the other context might call for some type of reimagination of the right?
I guess my response to that is that I simply don't agree with that concept of justice. I don't think that administrative tribunals should be able to develop the fundamental law, the Constitution of the country, in a way that you might get a different constitutional interpretation when you appear before the Rent Review Tribunal than you would get before you appear before the College of Physicians and Surgeons. And ultimately, I can understand how things can be contextual, but at the end of the day, freedom of expression should mean the same thing at its core, whether you're being disciplined by the Law Society or whether you're being prosecuted in Quebec under the the language rights there and so forth. And yeah, you're going to get a different balancing when you get to Section 1, but the cores of the rights, I think, have to be consistent.
Lauren, did you want to comment on that? And then
Yeah.
we'll take a break.
Yeah, and I think it's actually an interesting moment for Chris to make that observation, because of course many of us have been watching the Trinity Western submissions and speakers at the Law Society of Upper Canada and elsewhere, in which we may in fact be living in a world in a short number of weeks in which some law societies have chosen to recognize graduates, some haven't. The sky won't fall, but it will mean Manitoba may just be an interestingly different place than Nova Scotia, Ontario, than British Columbia. All thoughtful people, all in fact incredibly well equipped to give thought to discretion that's infused by not just charter values, but statutory mandates, et cetera, et cetera. And if Chris worries about that world of justice in which context and place can give rise to different kinds of decisions in similar kinds of contexts, I'm glad he doesn't practice in front of the IRB or the LAT or any tribunal in this entire country. Consistency is important, but the way to get there isn't one-size-fits-all cookie-cutter justice. It's development of clear reasons that can give rise to a body of understanding and be corrected from time to time when it goes awry. Guidelines, clarity, publicly available ways of predicting and understanding what you have to say, and importantly in tribunals as opposed to courts, decision makers who have an obligation to infuse their thinking with these values whether or not the submissions say it. Right? If courts do that, we're all deeply anxious about in what way are you taking on and arrogating to yourself a role that ought to be the parties in a passive, neutral, adversarial system. That's not the world of admin justice. The world of admin justice are a group of decision makers with a statutory mandate and policy set of purposes to advance and fulfill. And while that may include adjudication, it in no way relieves those decision makers of having to consider things like charter values, whether or not the people before them come with kind of educated lawyers and people who are immersed in this world of charter jurisprudence. And if we don't take that view, in other words, if we don't take the view of a bottom-up approach to a new kind of charter understanding, then I worry it really will be both a holy grail kind of world, and worse, a one-size-fits-all kind of world, which has very little resonance in the place where justice matters most. So, to finish my thoughts, as Matt was talking, I was thinking of my son, who's been watching kind of, Blitzkrieg-style seasons of The Walking Dead, and I keep going up to him saying, well, why do you care so much? It's just a bunch of zombies. Why are you, why are you identifying so much with the zombies? Because he's rooting for the zombies, right? And the rest of them are very flawed, very complicated people. The zombies are actually pretty clearly rooted in his mind. And he said, it's just a really interesting show when you look at it from the standpoint of the zombies. And I think when I look at the uncanny valley, I think it's absolutely right.
Nice.
If we bring just our lens to this, we see a bunch of zombies when we look at worlds we don't identify and understand. When we're the zombies, it's actually a much more interesting, important world.
Hey, that's perfect.
One quick point I'd make to Lauren is, Lauren sketched out a wonderful nirvana. But just keep in mind that those administrative decision makers who are going to give us a wonderful zombie world include those custom officers in the Little Sisters case who Lauren would say, oh yeah, let's have them develop an administrative justice system from the bottom up. I kind of like sometimes some top-down control.
Hey, Matt, you're the zombie robot guy. Do you have a final 10-second thought?
My final is not a zombie thought. It's that when Lauren was speaking, one thing I think that charter values eliminates is the fact that there are many options out there that are charter compliant, and so we don't need to be governed by the charter in every decision. There's a host of decisions that an administrative decision maker can make consistent with an act that are charter compliant, and that's what I think charter values tries to push out, that range of possibilities, like with the law societies.
You know, the ideal, from my point of view, with the panels is to leave everyone wanting a little bit more time to argue, to debate out the points and so on. And the point of these panels is not to resolve questions, but to raise issues, create debate, leave everyone with some things to think through, not only today, but going forward. It's been extremely interesting. Thank you so much, Lauren, Chris, and Matt. We're going to take a 15-minute break, and then we're all coming back here at 3:45 sharp for the final plenary. Thank you so much.